We know that Canadians value individual rights and freedoms, and the law is so important as an expression of those individual rights and freedoms. And the question today is the law being corrupted? And frankly, is it being turned on its head? So here to talk about the state of law today in our society and how the law is changing before our eyes is our friend John Carpay. John is the president of the Justice Center for Constitutional Freedoms. He's also a well-known author, and he recently authored the book Corrupted by Fear: How the Charter Was Betrayed and What Canadians Can Do About It. So a warm welcome to you, John.
Glad to be with you, David.
Well, John, I don't know whether I'm excited or very keen to talk with you about a issue that certainly weighs heavily on my heart, and that has to do with the state of law in our country, because it's not a kind of a simple matter, but it's like our law is being changed before our eyes, in the sense that a lot of us would intuitively be familiar with the whole notion of the rule of law, that we're all equal before the law, that we have these individual rights and freedoms. But is it too far to say that this is actually being shifted as more and more different assumptions are being put into how we define the rule of law in this country?
Well, I find it hard to talk about the abstract, but in terms of lack of respect for traditional freedoms that we have enjoyed in this country for about 158 years, and in centuries prior as well, part of our common law heritage from the United Kingdom. But we've got this Bill C2, the Strong Borders Act. I call it the Strong Surveillance Act, which, if it's passed in its current form, Canada Post will, for the first time in 158 years, will acquire the right to open mail without a search warrant. The use of cash in amounts 10,000 or more will be criminal. There are new powers for government officials to enter businesses without a warrant, new requirements on businesses to turn over their subscriber information. It's the focus. I mean, the title of the bill is about changing some of our immigration policies, some of our refugee policies, Strong Borders Act. But really, it should be 3, 4, 5 different bills separately to be properly debated. But they've lumped in this big fat bill. It's 120 pages. It amends a whole bunch of different statutes that are already on the books. And it takes us a third of the way towards becoming a police state where police have these incredible powers. So we're repudiating 158 years of tradition of respect, that whereby government must respect the privacy and the property rights of citizens. So government cannot open your mail or barge into your house unless they first go to court to get a search warrant. And in order to get the search warrant, they have to put forward some evidence that you are a suspect. So there's a concrete example of a departure away from 158 years of the government respecting our privacy and our property rights.
Wow, it's mind-blowing. So that's it. That's an example, isn't it, John, where government has the duty, we thought, to safeguard our rights and freedoms, and yet they're on the forefront of shoving it in our face and saying, yeah, we know we've got to have strong borders. Surely we know that by now.
And strong law enforcement. We need police to have the tools to catch the criminals. We want strong law enforcement.
Get rid of the bad guys.
And that can be and should be integrated with respect for our privacy and the sanctity of our home and our business and our property. That the government cannot just barge in on a whim.
Yeah, no, it's crazy. So back, this has been a tradition for some 1,000 years, 800 years to be precise, back in 35 with the
1215 Magna Carta.
1215, I stand corrected. You can't just simply go in without a warrant or reasonable cause. And yet that's exactly what they're opening up. So this is but this isn't the only area. This is Bill C2 at the federal level. So what's the status of that bill, basically? What's happening there, John?
Well, Parliament is recessed for the summer, so it was introduced. It got through first reading. First reading's kind of token It's like, well, let's just see what it's about. Second reading would be in the fall. And if enough Canadians contact their MP and say, Bill C2, the Strong Borders Act, is bad news, it cannot be passed in its current form. If enough Canadians contact their MPs, and if you had all of the NDP and Bloc and Green members of Parliament joining the Conservatives, you could actually see it potentially defeated in the House of Commons. But that's not going to happen necessarily unless Canadians really make it clear and make the effort to phone their MP or send an email to their MP and urge them to vote against the Strong Borders Act in its current form.
Okay, so people need to look at this critically, think, read it, and then act accordingly. So we know that in our judicial system, in law, that truth matters, evidence matters. And it seems like today more and more the law is being used for that purpose, but it's also being used for, I would say, devious practices where they're compelling us to think a certain way. And I think this is very concerning because we know that law as a form of public policy is foundational to our civilization. We have good law because we want fair rules. And if we think that the rules of the game are fair, then we can work together, we can cooperate, we can do great things together. But if you think the law has double standards and isn't based on evidence, then is that a problem, John?
Yeah, and I'll give you two examples again. We've got race-based admissions into public parks in British Columbia. It's an absolute disgrace. It's outrageous.
Can you explain that? Sorry, that is
so in the province of British Columbia, there are some parks where public parks, that are available to the public. That presumably they got some trails, or maybe they'll have a picnic table or whatever. Public parks. Some public parks in BC, you could only go in there if you have the correct ancestry, which is to be Aboriginal. And if you're not Aboriginal, you're not allowed into the public parks in BC. This is a sad example of something racist and a departure from the rule of law, where the rule of law should apply to everybody. So admission, if the public park is open from 10 a.m. to 10 p.m., that should be the case for everybody.
But you're saying,
don't have
but the
different
assumption
rules for
is that
different
we're all
races.
Canadian, John. We're all Canadian.
Yeah.
So, but that's all being put aside. There's different types of Canadians. Is that what we're getting at here in this application of law?
Certainly in British Columbia, with this policy of, and the Justice Centre, there's been no court action started, but the Justice Centre is looking into this, and we're hearing a lot from members of the public who are outraged that in British Columbia, non-Aboriginals cannot access certain public parks, or not on the same terms. Another example is a double standard on prosecutions, where you have the Crown prosecutors in Ontario investing huge amounts of time, effort, energy, money into prosecuting criminally some Canadians who participated in the peaceful Freedom Convoy protest 3 years ago in early 2022, and it's just incredible how much resources they're putting into this. And at the same time, in Ontario, you have a problem with accused murderers, accused rapists, those accused of serious assault, major crimes, are walking away without a trial, charges stayed, because the Crown says they don't have enough resources to bring the matter to trial within the required 30-month time limit. So there too, if you are, if you were protesting for the right cause, a cause that's liked by the government. So if you're protesting, against racism or against oil and gas energy development, or if you're protesting for LGBTQ stuff or Aboriginal stuff, you can get away with a lot and you're not going to be prosecuted. But if you're protesting against lockdowns and
the law then is being politicized. It's in terms of what is in alignment with the elite's kind of political orthodoxy. Is that what's happening here?
Well, very much so. Certainly, when you look at the Crown prosecutors, right, who they're prosecuting people who were against lockdowns and vaccine passports. They don't seem to be making a lot of effort to find the arsonists who burned down something like 100, or in any event, dozens of churches were burned down in the summer of 2021, and I'm not aware of a lot of resources being put into trying to find out the criminals, the arsonists who set fire to the churches. But you see immense resources being spent on criminally prosecuting good Canadians who participated in a peaceful protest.
I find that mind-blowing. So you have over 100 churches being burned, and there's not, to our knowledge, a single prosecution. I think of so many other cases. I mean, I think of the case of violence being perpetrated on the Coastal Link gas project, where thugs come on the scene en masse and go after equipment, make millions of dollars of damage, and threaten people. And there's not a single prosecution, to our knowledge. So it's like there's obviously officials giving direction to the police and others not to stand down. And I mean, that's a huge problem, because our justice system is made up of different actors. And if they're not doing their job, then don't we lose trust in this system, John? That's a problem.
Well, trust is eroding in institutions, and then some people like Chief Justice Wagner, as one example, we might get into that more, is very afraid of the decline of trust in institutions and doesn't seem to want to look at the possibility that the trust is declining because the trust is not being earned, right? Because the Crown prosecutors are not behaving in a way that merits trust. So,
well, why don't we bring up that clip with Justice Wagner? He spoke recently about his take on the state of law in this country.
There is no doubt that the rule of law and the judicial independence is under attack in many countries in the world. When you see governments attacking the media, attacking the judges, attacking the lawyers, and universities, of course, that means that there's a good chance that you're in front of a dictatorship, autocratic government. But there are many places in the world living through those events right now. And I think we have to be careful. So the message for the people is be careful, but be optimistic as well. Because in Canada, we have a strong legal system. We have our challenges, underfunding occasionally, delays, cost, but we have a strong judicial system. And we have good lawyers, good jurists across the country, well-trained. We have good law faculty, good law professors, great universities. We have good judges, well-trained judges, independent judges, impartial judges, and judges governed by ethical principles, which is not the case in many countries. And so that's why they should be optimistic about the future. But we have to defend those institutions. We have to defend the traditional media. We have to defend our courts, and we should not take anything for granted. But I think we should be optimistic. I think that the main stakeholders in Canada respect the separation of powers, respect judicial independence, and are happy to live in a country where the rule of law will prevail. Everybody is equal under the law.
John, there's that take from Justice Wagner, and I kind of half agree with him, but do you share his analysis? It's a little bit ambiguous, isn't it, John? But do you share his optimism?
I'm coming at it from a different perspective. Just by way of background information, and this is very important, he said publicly in 2018, there was a press conference, reporter asked him, and this is a slight paraphrase, but close to it, Chief Justice Wagner, people say that Canada's Supreme Court is the most progressive Supreme Court in the world. What do you have to say to that? And he said, it's true, and I'm proud of it. And so he has, that was the first time he wears it on his sleeve. He's a progressive. Well, you know, the courts should be above politics. If you're progressive, that means you're woke, you're left-wing, you're socialist, you're NDP, you're liberal. That's what progressive is, a political word, okay? And no judge should be publicly saying that they are progressive or that they are conservative, which would be kind of the opposite side of the fence. And so he publicly identified himself as a progressive, and then he spoke publicly. He condemned the peaceful freedom convoy in Ottawa. He said that these people were bringing anarchy and chaos, and he didn't intend that as a compliment. And so he is saying that Canada is just full of good lawyers and good judges and good law faculties and good law professors, and everybody is impartial and governed by ethical principles, and everybody's well trained, and everybody is, and so on. And he also says we have to defend the traditional media. So I'm thinking, these government-funded media are so utterly lacking in integrity. They don't adhere to basic standards of journalism, such as interviewing 2 or 3 people with different opinions. A good news story, a person should be able to read it. There should be enough info in that news story that you can actually formulate your own opinion one way or the other. Most of the media, it's propaganda, it's one side, it's one message, it's one narrative. And yeah, they might interview 2, 3, 4 people, but those 2, 3, 4 people are fundamentally, they're all saying the same thing. You don't really get disagreement. And so the government-funded media were absolutely horrible during the lockdowns and vaccine passports. And here we have the Chief Justice saying, we have to defend traditional media. Yeah. And he goes on, because last night I was up late, I was listening to the full hour. Half of it was in French, which fortunately I understand. And he just loves the government-funded media. He thinks that they're trustworthy, and that anybody who's not part of this traditional media, government-funded media, are spreading misinformation. And so this is really his mentality. So I guess where I agree with him is he says I'm a little bit worried about the lack of trust in the media and the courts and judges as they are currently. You know, there's this growing mistrust, but you know, don't worry about it. We'll probably still prevail in the end, but we shouldn't rest on our laurels. And I'm kind of on the opposite side of the fence. I'm saying, yeah, we've got some really serious problems with the judges today, and I've outlined that some of that in my book, Corrupted by Fear. When you have judges who are writing a media narrative into their court rulings, okay, those are not independent judges. Judges should be independent from media. Judges should not be parroting what they heard on the 6 o'clock news and writing that into their judgment, unless it's supported by evidence. So, yeah.
Well, so in this case, though, isn't it ironic that you have emerging in this country really a very strong emergence of the so-called living tree philosophy of the law, in the sense that a lot of our tradition in the Anglo-Saxon tradition is based on precedent, where judges look carefully at what previous decisions were made and basically built on that precedent, and were careful not to take their role that they were making new law, essentially. And I know that's a very limited kind of description of these two philosophies, but would it be fair to say that we've got most judges in this country now are really of the living tree philosophy of law? Or what is your take on this?
Well, I mean, if you get into, look, in 1982, Pierre Elliott Trudeau Americanized this country by adding the charter, which had not been part of our constitution before 1982, and the charter gave legislative power to judges. So judges could strike down laws if, in the judge's opinion, if it violated unjustifiably a freedom, one of the freedoms like expression, association, conscience, religion, peaceful assembly, travel, mobility, bodily autonomy, life, liberty, security of the person. And so, this is what we're stuck with. It is not easy to, and maybe it's impossible to find judges who are not going to be influenced by their own political leanings or tendencies or opinions, right? Because this is fairly objective. You look, for example, you take a look at the Charter Section 2D, which is a freedom of association. And it started out, I think, being properly understood as the right of every individual to associate or not associate as you please. And that should include the right to join with other people and form a union, and also the right not to belong to a union.
Yes.
And quite early on with the Lumine ruling, the Supreme Court of Canada, and this is a paraphrase and this is my summary, but they said, well, unions are wonderful and a source for good, and they interpreted freedom of association did not include a right to refuse to pay union dues.
Yeah.
It's like, no, you got to pay
Incredible.
union dues. If you want to be not a member of the union, okay, we'll allow you not to be a member, but you still have to pay dues, even if those union dues are being used for political purposes that you disagree with. Maybe they're being given away to a political party you disagree with. It doesn't matter. Even if your union dues are being given away to causes that you disagree with, you still got to pay your union dues. That's how the Supreme Court of Canada interpreted freedom of association. And it went further downhill from there to a point where the freedom of association is now interpreted as the right of unions to be properly consulted by governments. It's like it's been turned upside down. So, this is what's happened because the charter was added to our Constitution in 1982.
Yeah, exactly. So a lot of people would assume, well, judges are there to interpret carefully and respect how the law was written, its intent. But there's a whole new class of judges that don't see it that way. They see it as their prerogative to make the law. And I think that's a huge problem. And that explains, in part, I would think, John, where our country's at today, where you have enormous powers put on an ever larger state, an administrative state that kind of runs our lives. Is that how you see it, John?
Yeah, we've got something. So when the federal parliament or when a provincial legislature, either way, when they pass a bill, they give the cabinet, right? So that would be the premier and the ministers of health and education and culture and transportation, et cetera, or federally, the ministers of defense and international relations and finance and so on and so forth. So they give cabinet the power to pass regulations. These regulations have the force of law. They are just as much law as a bill that goes through Parliament. And what we've seen growing decade by decade by decade is that there are thousands, if not tens of thousands, of regulations where the cabinet, and they will often just kind of rubber stamp what the bureaucracy has given them. So you have the civil service, the bureaucracy will craft, let's pick something not too emotionally charged. Let's do some transportation regulations about, how big the truck needs to be and how much weight it can hold and how often it needs to be inspected and, whatever, right? All these things about trucks. But the bureaucrats can present to the cabinet, well, we want to add some extra regulations. We want to change regulations. The cabinet ministers, they're all pretty busy. Most of them don't know anything about trucks or transportation, so they will tend to sign off on it. And so you get all these regulations, which they've never been debated or discussed in Parliament or in the provincial legislature, whatever the case might be. So some people call this the deep state. it's not a term I use often myself, but you've got this situation where we have thousands and thousands of regulations passed by the federal and provincial cabinets that impact everything, health and safety and transportation and education and on and on and on. You could probably not read, it would take you certainly weeks and probably months to read all of the provincial regulations in the province that you live in. If you had to, if you're going to spend 8 hours a day just reading the regulations, just the provincial regulations of the province that you live in, it would take a long time to read all of those regulations. And yet those regulations have the force of law and impact our lives.
Yeah, so as a citizen, what chance have you to read all of them, let alone navigate them? And what I find
it's impossible.
Also,
it's hard,
impossible.
And you know what? It really hurts small business because the big corporations, right? Because a lot of these regulations apply to businesses. In fact, the vast majority of regulations, they're not directed at you and me. Like, you still have a sphere of freedom inside your own home. You know, it's not total. Maybe you got to get a permit to build a shed in the backyard, whatever. But at least in your own home, you can arrange the furniture the way that you want. We don't yet have regulations about how, you know, the couch has to be facing south and the comfortable chair has to face east. But for businesses, the big corporations, they can afford, the Coca-Cola Corporation, the Walmart, the Superstore, the Safeway, the Home Depot, the Canadian Tire, they all have enough money coming in that at their head office, they can have one person dedicated to ensuring the compliance with the equity, diversity, inclusion regulations, and another person with quotas, and another person with health, and another person with safety, and another person with fire safety. And the big corporations, they can have all these full-time staffers that are, you know, kind of breathing down the necks of all the employees of the corporation all over Canada. They can afford it. The small business, you're between a rock and a hard place because you have to also comply with all of these thousands and thousands of regulations, and you got to figure it out on your own and do the best you can, and hopefully you're not accidentally disobeying one of these thousands of regulations.
Exactly. So we know that we've got a serious economic productivity issue in this country. And it's no wonder if you have a proliferation of law, who can even scratch their nose, let it set up a business and move forward. So that's a huge problem. And I think the other irony to this is that it's well documented in report after report where many people can't afford a lawyer. So their ability to access the system breaks down. And if you don't have access, you don't have a rule of law, do you, John?
Well, justice delayed is justice denied. And we saw a big contrast in the United States when citizens challenged the government's the COVID restrictions, the lockdowns, the mandatory vaccination policies, etc. They got court judgments within weeks and sometimes months, weeks and months. In Canada, one of the Justice Centre's court actions, we filed a constitutional challenge to Jason Kenney's lockdowns in December of 2020, saying that they were unjustified violations of our freedoms of association and religion and conscience and so on. Didn't get a ruling until July of 2023.
Wow.
So it was 2.5 years later, we finally got a court ruling. We have a serious problem in Canada with not enough judges being appointed and serving on the bench, because whether your legal matter, whether it's criminal, you know, you're accused of a crime or you're the victim of a crime, either way, criminal matters, family law, civil litigation, you know, if somebody cheats you out of $1,000 in a contract, and constitutional law, it takes years to get a ruling, and that's a disgrace. And I don't think the judges are lazy. I think they're, you know, other than maybe one or two bad apples in a barrel, but they are hardworking, and there's just too few judges, and that's why it takes years to have cases move through the system.
So why doesn't the government make more appointments of the judges to get the system rolling so we get timely justice in this country? What's the problem, John?
Probably not enough political pressure on that point. I'm not sure how many citizens would be aware of this being a problem, or that appointing more judges is a solution. Certainly, the law societies, as far as I know, they have not been advocating for this. The Canadian Bar Association, so these lawyers' associations, the legal profession, they often lament the lack of access to justice, and they talk about how terrible it is, and they say that, lawyers should be more generous in doing pro bono work, and and perhaps that's true. I know a lot of lawyers do pro bono work. I don't know what the percentages are, but so far I'm not aware of law societies or bar associations advocating that we appoint more judges as a way to reduce the waiting times in courts.
Okay. So I want to bring up an interesting question, John. It relates to the role of evidence in courts as you see it. And I want to reference some particular cases. One is, it's interesting that recently we've had two prominent public health officials receive the Order of Canada, Dr. Bonnie Henry from British Columbia and Dr. Theresa Tam from the federal government.
And the committee that gave him the Order of Canada is chaired by the Chief Justice Richard Wagner. He chairs the committee that handed out the awards to Bonnie Henry and Theresa Tam.
Okay, so this is fascinating given what we know now about COVID-19 in terms of, evidence regarding their role in this issue. But even putting that aside, is the whole train wreck of public policy, I would suggest respectfully, in the whole area of safe drug supply. I mean, I noticed that if memory serves me correctly, the last 10 years alone, we've had some 50,000 Canadians die of overdoses in this country. And we can't put all of it on the doorstep of that policy, but we certainly can put much of it. And it's well documented on all kinds of fronts. And I ask myself the question, how is it possible that we would make such awards to arguably officials that I would suggest didn't really follow the evidence, and that narrative persists among different quarters within, judges that seem to not follow scientific analysis but follow media narrative, John?
I think a part of the explanation is in the same way that a huge ocean liner, the Titanic only had a few seconds or a minute to try to turn away from not crashing into the iceberg. And it couldn't do it because a big, huge machine that is just going through the ocean, it's not like a speedboat that can just, turn around quickly, or a large train on the tracks, right? It's moving along and it's not going to suddenly slow down. And so you still have the narrative is dying, but it still has inertia.
Okay.
I don't know if I want to say it's like a chicken with its head cut off, that you cut off the chicken's head and it keeps on running. Maybe it is like that, but we know from the facts, from the government's own evidence, that COVID was not this unusually deadly killer that the media were making it out to be every day of every week and every hour of every day. Just all the booga 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 scaremongering about this is going to be like the bubonic plague. It's going to kill tens of millions of people. Everybody should live in fear. That whole media narrative was false, and the anybody who thinks it's true should spend a few minutes looking at the government's death statistics, where you see that the deaths in 2020 were at the same level as in 2019. Or you had the same trends in most countries, slowly rising death rates with an aging population. So 2020 deaths were a tiny bit higher than 2019. But the death stats show that COVID was not something to be feared by. More than 99% of the population had no reason to fear COVID.
Right.
And yet you still have this inertia where you've got a committee chaired by the Chief Justice of Canada that's giving the Order of Canada. I believe it's the highest order you can, the highest level of recognition you can get. It is being given to these very incompetent people who caused massive harm and suffering on millions of Canadians, and they still don't have the honesty to take a hard look at the lockdown harms. Mm-hmm. So, yeah, the Order of Canada, I think, has become a joke, really. Okay. And it's unfortunate for the good people. There are some very worthy, deserving individuals that have received the award as well, but it's becoming a joke.
It's really concerning. On another front, it's fascinating. The other week, I noticed that there's a judge in Alberta that blocked the province's ban on puberty blockers and cross-sex hormones for minors, ruling that denying trans-identified youth these interventions would cause irreparable harm. I have had the honor of reading from the UK the famous Cass report, and I recommend anyone who cares about this issue to read it, by the preeminent pediatrician, Dr. Hilary Cass. It was a meta report. It was far-reaching. It looked around the world in terms of data and really utterly destroyed this so-called gender affirmation treatment approach that so many health professionals in Canada now are undertaking. And I just marvel at the silence in this country to the Cass report and so many others. Now, so Canada, in contrast to the UK that has shut down these gender clinics, the Netherlands, Sweden, Finland, just to name a few, we are now, in this country, the outlier when it comes to the whole use of gender affirmation, when it comes to these complex cases that are presented by children. They need help from real health professionals who help them, not some kind of use of ideology to whisk them off to puberty blockers and surgery and all the rest. And I find it stunning that a judge wouldn't reference the evidence from the Cass report. It's kind of the gold standard when it comes to scientific evidence. And yet they're following the cues, not of evidence, but almost of what I would describe as activists. Isn't that a huge flag, John?
It's a very disappointing ruling. So the Alberta government in 2024 passed legislation to prohibit giving puberty blockers and opposite-sex hormones to children or teenagers, whatever term you want to use, minors under the age of 16. And this was, as you mentioned, David, we've got the United Kingdom is backing away from its previous policies of, the moment that a boy says that he's actually a girl, he's a girl trapped inside a boy's body, he wants to be a girl, etc. And what they were doing, and what most provinces are still doing, is they say, oh, okay, well, we're going to give you puberty blockers and then you can take estrogen. Problem is, if you take puberty blockers and estrogen, the boy will never mature sexually. He will probably never become a father. And the same for the girl. Girls who take puberty blockers and testosterone, they will develop a permanent male voice, a deep voice that cannot be changed or reversed, and facial hair for the rest of their lives. They will not menstruate. They will not become females that can conceive babies. So this is permanent, irreversible damage to kids. So horrible. The Alberta government, headed by a woman who is not a churchgoer, not a social conservative, for whatever that's worth, but she looks at this and says, this is not the right way to go. So the United Kingdom has backed away from this approach, as have Norway, Sweden, Denmark, Germany, Italy, all over the world. We are retreating away from, either partially retreating away from or entirely retreating away from giving puberty blockers and opposite-sex hormones to teenagers. And so Alberta is in line with the rest of the world. The evidence is that there's a lot of harm. A lot of the long-term evidence is not even available yet right? We don't know yet, because this is so recent. It might take another 5 or 10 years before you really get to see the long-term effects. How many of these teenagers, when they're 25 or 30, are going to be saying, you let me, as a minor, make a really stupid choice that led to irreversible physical changes and permanent infertility, and now these people are 25 or 30 and they want to become mothers or fathers, they want to have kids and they can't have kids because of the puberty blockers and opposite sex hormones. So the judge really didn't explain. Here's the disappointing thing. She did not explain why she accepted the evidence of the gay rights group, Egal Canada. They had their expert reports and they had their evidence, okay. The Alberta government had their evidence. She lists what the evidence is, okay, so this is Justice Alison Kuntz. She says Egal Canada argued A, B, C, D, E, F, G, and goes through it. And then she says the Alberta government argued A, B, C, D, E, F, G, and goes through it. And so you're reading this, and then you're getting closer towards the end of the judgment, and you're thinking, okay, so maybe she's going to explain why she thinks that the gay rights group evidence is stronger, better, more persuasive, right? And you get to the very end of the judgment, there's no explanation offered. She just asserts, and she uses very biased language. She calls the giving estrogen to boys and giving testosterone to girls, she calls that gender-affirming hormone therapy. That is gender-affirming to give a boy estrogen. Just incredible.
It's incredible. So is that going to be appealed, John?
We'll have to see what the Smith government chooses to do, or the lawyers working for the Attorney General, whatever. They could appeal that. This is an interim injunction, but because these court actions move so slowly, the interim injunction means that the Alberta's very sensible policy to protect children will not be enforced for the next 2 years until there's a more full
but the point is that evidence should matter, and we've got what appears to be a judge not looking seriously at evidence, and this does real harm to people, including children. Another case I did want to cite, I find very interesting, John, has to do with, in good public policy, we need good accountability, we need transparency. And I was fascinated to read in Blacklock's report that it's been discovered that a judge has sealed an ArriveCan report regarding the kind of the long saga. An internal ArriveCan investigators report, long sought by MPs, has been sealed by the federal court order. A judge blocked distributions of the findings at the request of Cameron MacDonald, a former Canada Border Services Agency director, briefly suspended over the $63 million program. So here you go. You have a judge, Justice Henry Brown, who sealed it, when in fact, wouldn't there be an argument that in order for the law to be able to be based on evidence, we have the exact wrong decision being made, namely to seal it and keep it away from the public and in fact, decision makers. Are you familiar with that case?
I'm not familiar with the case at all, but as a general principle of law, the internal workings of government should not be shielded from the public. I mean, quite the opposite. It's the public that's paying the tax dollars to make that happen. There can be valid grounds if there is a very sensitive cabinet discussion about dealing with a particular crisis, a particular emergency. And the reason behind that is that when we are speaking privately, we have far more freedom to speak honestly, right? If you really want to have a really frank discussion with somebody, the worst thing to do is, put out your tape recorders or, have it live streamed on the internet. You might get an interesting, feisty discussion, but it's not going to have that level of honesty.
So, John, the other part of our justice system, we've got different components to it. We've got the legislature, we've got, of course, lawyers and police, judges, the whole bit. But one of the things that fascinates me is what's happening to law societies in this country, where it seems like for them, evidence doesn't really matter. So, for example, in BC, we've got a law society that denies defaming a lawyer in a dispute over unmarked graves. This is Victoria lawyer Jim Heller says the Law Society of BC's descended into an impermissible degree of argument in addressing his allegations of defamation. So he's saying, like, what the heck is going on if in their training regarding, quote, reconciliation, the Law Society of BC is claiming that you have to say that there were unmarked mass graves, when in fact there's no evidence to suggest that there are. So what's going on here, John?
Yeah, that's pretty scary. I think this refers back to 2021 when the Kamloops Indian Band made the false claim that 215 children were buried, and all they had was ground penetrating radar, which will beep if it hits a tree stump or a rock. They've received millions of dollars to excavate, because the only way you can find out whether bodies are buried there is through excavation, which costs money. So they got a grant. And here we are, we're 4 years out, and there's been no excavation done. I think that tells you a lot. I mean, if you love the truth, you want to find out about these supposed, if there's people buried there. I would add, though, if you did find bones of people buried, that does not tell you how they died. So and even if they're children's bones, I mean, there was a lot of tuberculosis was a very deadly killer 100 years ago. So yeah, this is just ideological. It's a woke oppression narrative that, non-Aboriginals have oppressed Aboriginals, and this story plays well into the narrative suggesting mass murder. And here you have another example of a lack of integrity amongst the media. They just repeated these claims and ran them as true. There was no proper skepticism. Journalists should be skeptical and say, well, okay, I hear this. Well, I don't reject it as false. I don't accept it as true, but I'm going to investigate it, and I'm going to see what other people say. And no investigative journalism.
But this is the point, is that of all the professions, it's the lawyers on behalf of the law, on behalf of society, and the law societies that should be standing up for truth. And I don't care what your race is or your claim or whatever, we have to know what the truth is. That's what matters, because if we don't have the truth, we don't have anything. We don't even have a civilization, do we, John? I mean, that matters.
Lack of love for truth is, well, it's always been a problem. I mean, we shouldn't pretend that this is unique to Canada in 2025. But, truth is important, and we should base laws on truth. We should base our science, our medicine on truth, our morality and how we live, et cetera, et cetera. And the traditional ideal in the media was you pursue truth. Therefore, you are skeptical. When you hear something, you don't immediately reject it as false, nor do you immediately accept it as true, but you're skeptical, you research, you investigate, you interview people, you explore. It's that love for truth that, to a greater extent in years past, motivated the media profession. The love of truth should be for courts as well, so that they're actually looking at evidence that's placed before them and not just repeating a media narrative that the judge has heard dozens of times. Law societies really being responsible for the competence and honesty and integrity and professionalism of lawyers. Law societies should lead by example and should love truth. And so when you have a political indoctrination course where lawyers are told you have to accept this whole mass graves unproven thesis as fact, that's a serious problem. In Alberta as well, as a condition for practicing law, lawyers in Alberta must complete a political training course in which they are kind of required to accept this woke, progressive narrative in regards to Aboriginals and issues related to
I think
Aboriginal
that's
rights.
for all the. I believe that's the case for all the provincial law societies now, as they're they're introducing an entire training program where people have to accept. It's almost like they're going to a woke university seminar on cultural Marxism. It is truly bizarre. So that's a very concern. So we've had a far-reaching conversation about the importance of the law and whether the rule of law, frankly, is being undermined. And I thought a very interesting case also came up this week, John, about the whole issue of technology and the challenge of AI, artificial intelligence, having embedded in it a kind of a bias that could pervert the law. So, for example, this came out in the case where lawyers were, quote, busted using fake case law. This was in the United States regarding a legal case for Michael Cohen, Donald Trump's disbarred personal lawyer and fixer, as he was labeled. And would you believe that his lawyers were handed this document? Apparently it was generated by AI. And in fact, it was false case law. And I know that AI has been used for a lot of things. It's a very powerful tool. But we also have concerns that within it is an embedded bias that could really create a lot of chaos and, quite frankly, disinformation. Do you share that concern?
Well, I do, and it would be worse if there was only one AI software. But I read recently that people have developed an AI with a conservative slant. Other people have developed an AI that's very broad-minded. So there will be different search engines in place. One good thing that a lot of the courts have done is that they require lawyers to tick off on a box whether or not they've used AI in preparing their brief or factum. And if yes, have they carefully reviewed and read everything themselves and come to their own conclusions. But it is a disconcerting trend where the AI can actually give you fake cases, and they'll say, well, in the case of Smith versus Jones from Saskatchewan, 2014, SKQB, blah, 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 and it looks like a real case, and it's got that citation at the end of it. The court held that blah, 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 blah. And if that's all fake, so at least the courts are taking notice of it and putting pressure on the lawyers to actually say, did you use AI, yes or no? And if you did, will you confirm in writing that you have read every case and read through it all so that it is actually your own work and your own content?
Very good. So as we wrap up our discussion, I want to turn to what I see as perhaps signs of hope. And I want to play this clip from Premier Doug Ford as he talks about the amazing number of cases of criminals being let out on the street again.
And as for releasing, I'm not going to go on my rant again, but I can't tell you how many messages I got from my little rant yesterday, and it doesn't matter what race, creed, color, status in society you are. I just got flooded full of messages saying it's about time someone's calling these people up. You can't have the largest drug bust in the history of Peel, 500 kilos of cocaine, and out of the 6, I think 1 is in jail. They're all out on bail for the second or third time. It just doesn't cut it with the people. They're frustrated, and then getting cars stolen and kicking doors in and walking into grocery stores with hockey bags. And it's happened at LCBO, and they just start loading everything up. You can't run a province or a city under lawlessness. There has to be accountability. These people have to go to jail. These judges cannot keep letting people out on bail. It's crazy. And then people shooting up other people's houses. The other bus, that's 15 people, and they're all out on bail too. I think 1, they kept them in. But then we find out they were already out on probation. So what gives? We have to throw these people in jail, and we have to be tough on crime. And this is a conversation we're going to have at COF when we get together and the FMM meeting with all the premiers. I think it's this week, I believe.
So is that a sign that politicians are finally waking up, that people are tired of people not being accountable for the crimes that they commit, John?
Well, it seems like it. I mean, the bail issue is complicated because there are some people that are charged with crimes that are not a threat to society, and so you do get out on bail. Not everybody should be locked up during trial.
But 500 grams of cocaine, John.
Kilograms.
And they're back on the streets. Kilograms,
Yeah.
pardon me. It's not, it's even more. Yes.
Well, most politicians are followers, not leaders. And so, this is an example. He mentions all the messages that he's received. And
Indeed.
I think we have to keep the same thing in mind when it comes to the Strong Borders Act, Bill C-2, that the MPs need to hear from Canadians to vote against moving Canada towards becoming a police state where the government has these massive powers to violate our privacy. It's important for people to email their MPs and phone their MPs.
Well, John Carpay, president of the Justice Center, thanks for joining us today, because we know that the rule of law matters, and so does the voice of the people. So thank you for joining us, John.
Thanks for having me on your show, David. Much appreciated.
Thank you for watching Leaders on the Frontier. We're a nonpartisan think tank. We explore ideas, policy, and practical solutions that can make a difference in the lives of Canadians. We do not accept any government funding. We work for you. Thank you for supporting Frontier. Visit fcpp.org to give. While you're there, be sure to check out our latest articles and research. Without open discussion and debate, you're not thinking, nor are you free. Comment below. We'd love for you to join the conversation.